family of Buckner.
Can you please turn on your screen?
Can you see me?
I can see you, but now you have, all right, we'll see if that noise starts up again, giving us some numbers that I could not. All right, we're here for non-jury trial today. Are we ready to proceed?
Yes, Judge.
All right. Anybody want to give opening statements?
Judge, the people will waive opening statement.
Defense will likewise waive, Your Honor.
All right. You may call your first witness.
Thank you, Judge. The people call Sergeant Jordan Irbies to the stand.
Sergeant Irbies, please unmute your device for me and raise your right hand to be sworn. Sergeant Irbies, do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I know you've testified before, so I don't need to give you any direction. Is that correct?
Yes, Your Honor.
Thank you. You may proceed, Ms. Woods.
Thank you, Judge. Sergeant Irbies, could you please state your name again for the record?
Sergeant Jordan Urbis, E-R-B as in boy, E-S.
And where are you currently employed?
Washtenaw County Sheriff's Office in the Police Service Division.
Okay. And were you employed in that capacity on November 17th of 2024?
I was.
On that date, were you involved in an investigation involving Lawrence Buckner at 1501 South Huron Street in Ypsilanti Township?
I received a complaint from him, yes.
What do you mean by that?
I was asked to call him in regards to a trespass notice that was served to him earlier that evening.
And did you call Mr. Buckner?
I did.
What phone number were you provided to call?
734.
Thank
And
you.
why were you given the task to call Mr. Buckner?
He was upset for being served a trespass notice to the improper address.
So he was given a trespass notice, but it was to the wrong address?
Yes, so Deputy Jay Clark had served him a trespass notice earlier in the evening. There are two Sunocos. It was supposed to be to the Sunoco at 350 South Ford Boulevard, but Deputy Jay Clark mistakenly issued it to him at 1024 Ecorse Road, which is the second Sunoco gas station in Ypsilanti Township.
So you were calling to just give him the correct information?
He asked to be called in order to make a complaint about being served the improper address.
Oh, so Mr. Buckner was complaining, so you were just
Yes.
calling to follow up on that complaint?
He asked to speak to a sergeant, and I was the one that was on duty at the time.
I see. Do you recall what time you called Mr. Buckner?
I believe it was around 1:30 a.m., somewhere in that time frame.
Okay. And are you familiar with Mr. Buckner's voice?
I am.
And when you called Mr. Buckner, was this call recorded?
It was recorded on my body-worn camera.
Judge, may I share my screen?
What are you sharing?
Before we even get into testimony, let's talk about what makes this case so explosive, because this isn't just a routine criminal trial. This is a malicious use of a telecommunications device case, which means the prosecution is arguing that words alone crossed the line into criminal behavior. No physical contact. No confrontation in person. Just a phone call, and the consequences that came with it. The center of this case is a defendant who believes professional officer. A recorded phone call that doesn't care about excuses. And a judge who isn't interested in narratives, only facts, intent, and credibility. Pay close attention here, because this case turns on one simple question: when does talking become a threat? And once that line is crossed, there's no talking you're
Talking to.
I've had numerous incidences with Mr. Buckner previously, so I'm quite familiar with him and his voice and his mannerisms. And that phone call was consistent with previous contacts I've had with him. And him being the person that was served with the trespass, he would be the only one at that point in time that would know that the trespass was served at the improper address.
And do you see Mr. Buckner on the Zoom today?
I do.
And could you please describe him to the court? Or
He's wearing a black t-shirt with a chain. His Zoom video is labeled Mr. Buckner.
Judge, may the record reflect that the witness has identified the defendant, Lawrence Buckner?
No objection, Your Honor.
It shall.
So, who was, when Mr. Buckner had stated on his phone call, if he approached me at the pizza place, I'm gonna beat the fuck out of him. Do you know who Mr. Buckner was referring to?
He was referring to Deputy Jay Clark. And I say Jay Clark because we have 2 Clarks that work for us.
Okay. And did you take what Mr. Buckner said to you as a threat on Deputy Clark?
I did.
Okay. And when a threat like that is made to a law enforcement officer, what are you required to do?
There's not any specific requirements, but I made sure to notify Deputy Jay Clark so that he was aware that the threat was made. And then, due to the likelihood of it, if it was going to be carried out, it would possibly be that night. I notified the other deputies on shift in case something occurred with Mr. Buckner.
Did you believe that threat that Mr. Buckner made?
Yes, considering it was made to a sergeant and it was pretty brazen and it's well aware of who we know who he is, I did take it as a credible threat.
Okay. And how did this threat on a fellow law enforcement officer make you feel?
It concerned me for the safety of my deputy in the event that he was reserved that trespass notice, or in the event that they did come in contact with him in the community again that later that evening or that week.
Do you believe that this threat was intended to frighten, intimidate, or annoy or disturb your peace?
I do.
Your Honor, I'm going to object to that question as speculation and/or calling for a legal conclusion.
Response.
I'm just asking for the officer to elaborate on how that made him feel. I can rephrase my question, Judge.
Okay, please rephrase.
Officer, when you received that threat from Mr. Buckner, how did that make you feel?
I was frightened for the safety of my deputy.
Okay. And why were you frightened for the safety of the deputy?
The fact that a comment like that was made directly to a law enforcement officer, that's not in the typical realm of things that happen. So the fact that he was willing to make such a brazen.
The defense waiving an opening statement, especially in a bench trial, usually signals that they don't want to lock themselves into a story they might not be able to support once the evidence comes piece. Judges are trained to strip cases down to their bones. They don't care who feels wronged, they care what was said, how it was said, and whether the law applies. So when the prosecution confidently moves straight to their first witness, it's a strong signal they believe the evidence, especially the recording, is airtight. This is the calm before the storm, and once testimony starts, there's no hiding from what's already been captured.
Label?
Thank you, Your Honor. Deputy Urbis, one of the things you said on the phone call was that you knew Mr. Buckner was lying to you. Is that correct?
Correct.
And what you were indicating, Mr. Buckner, that you believe he was lying to you about was whether he had encountered Deputy Clark. Is that correct?
I believe it was whether Deputy Clark had a problem with him specifically or not.
One of the things you said in that call was that he hadn't been at the sheriff's department long enough to have any contact with Mr. Buckner. Is that correct?
To have significant enough contact for him to have a vendetta against Mr. Buckner, yes.
Fair to say that you were incorrect and that Mr. Buckner had contact with Mr. Clark.
Yes, he had contact. I don't believe I refuted that he had contact.
So fair to say that Mr. Buckner was not in fact lying to you?
I mean, it depends on how you're interpreting what Mr. Buckner said. So the reason that
Certainly.
Okay.
So additionally, you said earlier that you took this threat seriously.
Correct.
Now on the video, we heard you laughing immediately after you stated out loud that it was a threat.
Correct.
Would you generally laugh after you hear a serious threat towards a law enforcement officer?
Well, that was my response at the time because I thought it was so brazen, and I was surprised by it. It kind of caught me off guard. I didn't expect that to come.
Okay, so I guess, okay, and earlier, the prosecutor asked you how you felt, and you initially said concerned.
Mm-hmm.
Then there was another question the prosecutor asked you where there was an objection and a rephrase. She re-asked you that question, and then you changed concerned to frightened. Do you remember that?
Correct. Yes.
Why did you make that change?
Well, I can feel frightened at the same time that I can feel concerned for my deputy's welfare.
You certainly can, but I'm asking why you changed your phrasing the first time the question was asked to the second time the question was asked.
I don't have a answer for that.
Did you change that phrasing as a result of how you felt it would influence the outcome of the case?
No,
Okay. Now, after Mr. Buckner made that statement, because he approached me at the pizza place, I beat the F out of him, he hung up right away, didn't he?
correct.
Did he try calling you back?
No.
Okay. And how did you determine that the he was talking to was Deputy J. Clark? Was it anything other than the context of the call?
I believe he said Deputy J. Clark in the phone call. He said Deputy Clark in the phone call, identifying him.
At the end of the call, I heard was he. Did you hear something different?
I'd have to re-listen to the body cam again, but I believe that he did
Okay.
say Deputy J.
Okay,
Clark.
so why don't we play it again? And Your Honor, may I share my screen to share the...
This is a critical clarification, and it completely undermines any argument that law enforcement was harassing the defendant. The officer didn't seek him out. He wasn't patrolling for trouble. He was responding to a complaint made by the defendant. The call was administrative. Correcting an error on a trespass notice. Explaining the proper address. Uniform.so. When the conversation later turns hostile, the responsibility for that shift becomes very clear. This officer walked into the call calmly and professionally. What happens next is entirely on the other end of the line.
And what kind of laugh would you say that was?
It was more out of shock than anything else that he had just said that and then hung up.
And he hung up the phone on you, correct, after he made that threat?
Correct.
Okay. Was that a laugh could that be described as a happy laugh?
I would say it was more of like a holy crap. Like he just said
Okay.
that.
Okay. So more like a nervous laugh. Is that what you're saying?
I would say that would be a way to categorize it, yes.
Okay. And did you end up reporting this after this happened?
Reporting it in terms of,
For charging.
yes,
And why did you do that?
because I believe the threat may be credible.
I have no further questions, Judge.
Thank you, Mr. Lebo.
Very briefly, Your Honor. Sergeant Irby, were you laughing because you were looking forward to submitting charges against Mr. Buckner?
No.
Okay.
Shocked reaction.
Fair to say that throughout the conversation with Mr. Buckner, far before you made that statement, you were generally fairly impatient with him?
Yes.
Fair to say you're not a fan of Mr. Buckner?
I wouldn't describe it as that. I've had a lot of dealings with him.
Thank you. I have no further questions.
Thank you. May this witness be excused.
Yes, Judge.
Yes, Your Honor.
Thank you, Sergeant Ebbers. You may be excused. Any further witnesses in the prosecution?
No, Judge, and the people rest our case.
Thank you. Any witnesses from the defense?
No, your defense rests except for closing argument.
All right. Did you want to talk to your client before you say that, or you've already talked? Do you need to make a record of anything?
I will make a record, Your Honor.
All right. You're gonna make a record or later?
I can do that now, Your Honor.
Mm.
Mr. Buckner, do you understand that you have a right to testify in this case, sir?
Yes.
Okay, and are
This is the moment every criminal case pivots, because body-worn camera footage doesn't argue, exaggerate, or forget. It simply records. And when prosecutors introduce evidence like this, they're not doing it for drama, they're doing it because it removes doubt, the documentation. Once this footage is admitted, the case stops being about opinions and starts being about proof. Judges love this kind of evidence because it replaces speculation with certainty. At this point, the only question left is whether the defendant's own words crossed the legal threshold. And once we hear them, that answer becomes painful.
Buckner, additionally, I would like to just voir dire and to place the testimony on the record. Mr. Buckner, have you decided to waive your right to testify in this case?
Yeah.
Thank you.
All right. So, Mr. Buckner, you fully understand you have a right to testify, at which time anything you say can and will be used against you in a court of law. You're choosing to waive that right and not testify today. Is that you're choosing to not testify today, and you're not going to exercise your right to testify? Is that correct?
Yes.
All right. All right. I guess we can proceed with closing statements with the people, please.
Thank you, Judge. So, Judge, we heard testimony from Sergeant Irby's. We know this happened in Ypsilanti Township, and we know that the defendant made these threats through a phone. The telephone number was also put on the record. We actually saw the phone call that was used to communicate between Sergeant Irby's and the defendant, Mr. Buckner. Second, that when communicating with Sergeant Irby's, the defendant threatened physical harm to another person or to any person. It doesn't even really matter who that person is. Sergeant Irby's believed that that person that he was threatening happened to be Deputy Clark because he spoke about Deputy Clark. He actually said that he had a beef with Deputy Clark. He told Sergeant Irby's that that he has a beef with him, he wasn't happy with him, that there was issues going on with Deputy Clark that Sergeant Irby's wasn't aware of. And then he said that if he approaches him at the pizza place, that he's going to be.
And there it is, the exact moment everything changes. The defendant doesn't hint. He doesn't joke. He doesn't speak metaphorically. He makes a direct statement about beating, and more damaging is how immediate and clear the response is. The officer identifies it as a threat on the spot. There's no confusion. No misunderstanding. No ambiguity. Once those words are spoken,